This is American Government Monday, September 14th, 2020. Today and Wednesday and Friday will begin a very intensive overview and review of the Constitution of the United States. We've seen how the country came together in a declaration of its principles in the Declaration of Independence, and how it struggled to create its first constitution, the Articles of Confederation, which then failed as a system of governance. And then we examined in the last couple of weeks how the Constitutional Convention came together, the Federal Convention of 1787, weighed the different plans, and created the Constitution of the United States. And as I closed that lecture on Wednesday last week, suggested the three great institutional novelties, the new kind of federalism, which we'll turn to next week, by the way, and examine the relationship between the federal government and the states in the constitutional system, and the extended republic, the world's first huge, populous, and geographically huge republic, and the Republican constitutional executive, the vigorous executive, but grounded in Republican popular sentiment and limited by the Constitution. So then on Friday, we examined Federalist 10 and 51 for the theory of the U.S. Constitution, and then on last Monday, we examined the specific issue of race and slavery in the founding. So this week, we're going to now take apart and examine very thoroughly the Constitution which the founders created. Most of the work of this week is going to be done by you, the students, answering the preparation and review questions on the Constitution. I've divided them into three parts, and roughly my discussion of the Constitution in these lectures is going to provide a structure for analysis. How do we look at different parts of the Constitution? How do we understand them? And specifically, today I'll give an overview of the overall structure of the Constitution and the basic nature of the 7 original articles. On Wednesday, we'll look at the internal structure of Articles 1, 2, and 3 that set up the branches of the national government. And then Friday, we'll examine the 27 amendments to the Constitution. The Constitution is a relatively short document, 7 pages, compared to other constitutions. The Constitution of India, when I was in India in 1990, the Constitution of India was 237 pages long. The Constitution of the European Union is 510 pages long. So as written constitutions go, the first constitution, the first truly successful written constitution in the world, the United States Constitution, is actually one of the shortest and we'll see pithiest. As I walk through the overview of the Constitution, I just want to direct you to the last page of my notes, which is a comparogram. It's a rough schema of the original 7 articles of the Constitution and their basic themes, which we'll turn to more specifically on Wednesday. Now, I want to start with 5 different tags or 5 different labels for understanding what a clause or an article or a section of the Constitution is doing. In some ways, there are 2 nice analogies to what the Constitution reveals about in terms of American political life. One analogy is architectural. The Constitution is the blueprint of the country, of the nation. And in the same way that a building is built around the blueprint, and different rooms have different functions. There's a parking lot if it's a skyscraper, a high rise. There's obviously a different purpose and structure. And in the same way, the different parts of the Constitution are constructed so as to achieve different purposes, just like an architect designs parts of a building for different purposes. The other analogy that's useful is biological. The Constitution, some political commentators have said, is the DNA, the deoxyribonucleic acid of the nation. And in the same way, there's an interesting, just an interesting side bit. I've always had an interest in the study of identical twins, especially identical twins separated at birth who don't know of each other's existence. There's a whole subset of study of these individuals. And it's remarkable how often similar, often identical, the themes and issues of their lives are, and yet how different they are. What do you conclude from such a thing? And some geneticists and psychologists conclude that our DNA is about 50 to 60% of who and what we are as individuals, and the rest, of course, are our upbringing and environment. And in some ways, that's a useful analogy. The Constitution isn't the whole of American political life, but it's the foundation. And it's the structure, the skeleton, the DNA of our national existence. There are important parts of our political system that are not spoken of in the Constitution that developed afterwards, such as the committee system in Congress, which we'll talk about, or the party system. Um, but basically, the essence of our political existence is contained in the Constitution. And in some ways, the framers have been remarkably successful in creating a constitution that, as Chief Justice John Marshall has said in a couple of weeks, we'll read in McCulloch v. Maryland, that was intended to endure for the ages and to enable to take a nation through the great crises of national existence. Our Constitution has done that for almost 250 years now. It's taken us through a civil war, through economic depression, world wars, and I guess one of the questions of our time is, will it help us to weather the troubles of the day? So, with that in mind, let me introduce what I consider to be 5 functions or purposes, ways of describing a part of the Constitution in terms of what function it's doing. Let me get the 5 terms out, and I'll come back and describe them. A purpose, a part of the Constitution, a clause, an article, a section can be declarational. It can be structural. It can be procedural. It can be relational. And 5th, it can be limiting. So let me go in turn and explain what I mean by each of those 5 designations. So a declarational part of the Constitution, whether it's an article or a section or a clause, declares or states a core fundamental principle, function, or purpose. So I'll give 3 examples. The Preamble, we the people of the United States, etc. It declares the source of authority of the Constitution, the people of America, and declares the 6 specific purposes that the constitutional reform from the Constitutional Convention of 1787 promulgated, such as a more perfect union, domestic tranquility, common defense, etc. The opening clauses of each one of the first 3 articles of the Constitution, Articles 1, 2, and 3, which we'll see are essentially structural, more about that in a minute, declare an important principle. The first clause, Section 1 of Article 1, Article 2, Article 3, are called the vesting clauses. On Wednesday, I'll come back and describe more what it means what a vested power is, what a vested right is, what that term vested means. But just what you should know now is, for instance, the opening clause of Article 1 says, all legislative powers herein granted shall be vested in the Congress. It states that the power to create laws in the United States is vested in this institution, and this institution and not the other 2 institutions or branches of government. So the vesting clauses, the executive power shall be vested in the president. That's Article 2, Section 1. Article 3, Section 1, the legislative power shall be vested in one Supreme Court and such inferior courts. It states a principle that this institution owns that power. Obviously, the idea of the vesting clauses is an embodiment of the separation of powers, which the Constitution creates separated institutions to embody the separated powers and declares what those powers are. The opening clause of Article 6 declares the principle that all debts and agreements created under the old Articles of Confederation will be valid under the new Constitution. Why was that statement or declaration important? So that the contracts and laws and treaties of the old Confederation would not be invalidated by the new Constitution. Many revolutionary governments often waived the debts of the prior regime. The framers wanted to make sure that the credit of the United States, flimsy as it was at that time, would nevertheless be good by guaranteeing that we would still uphold our old debts and obligations. So a clause can be declarational, stating or declaring a core principle or purpose. The second way of describing a part of the Constitution is structural. Structural, I mean, it actually creates the structure, the building of an institution. And typically in a constitution, what are the structural elements of an institution? Membership, for instance, and qualifications for office. You will learn, for instance, that each of the qualifications for the national government, each of the offices of the national government, have specific qualification as to who and who can't be a member. If you didn't know by the PRQs or by general history or your civics, you know that to be a member of the House of Representatives, you have to be 25 years old. To be a member of the Senate, 30 years old. To be a president, 35 years old and a natural-born citizen. And as you will discover, there aren't specified qualities for the Supreme Court or for the courts. That's not to say that the framers didn't anticipate that people would require qualifications, but they're not specified in the Constitution. So what are examples as structural parts? I just mentioned the vesting clauses. The first clause of each article of the Constitution, the first section that states what kind of power that branch, it declares what kind of power. Those clauses are also structural. How so? Article 1, Section 1 says, all legislative powers herein granted shall be vested in a Congress to consist of a House and Senate. So already in the first line of Article 1, you learn a structural piece of information. In our discussions last week, we called, in distinguishing between the Articles of Confederation and the New Jersey Plan, we saw that they had a unicameral legislature, a one-house legislature. The Congress, under the Constitution, is a bicameral, and you learn that piece of structural information right in the first line of Article 1. Article 2 says, the executive power shall be vested in a president. You learn a structural piece of information about the president, that it consists of one person. We saw in the Constitutional Convention, the framers weighed, before they made the choice for a single executive, they weighed the possibility of a plural executive, a committee executive. So as we're going to see, that principle is called unity in the executive, and that's a very important part of the founding. In Article 3, Section 1, the judicial power shall be vested in one Supreme Court and such inferior courts as Congress shall from time to time establish. You learn that the judiciary under the Constitution has a hierarchical structure with one court at the top and courts below it. So a structural clause or article sets up an institution in terms of its size, its shape, and how it embodies its function. The next way of describing a clause or part of the Constitution is procedural, where the Constitution sets up a series of steps or rules or procedures that have to be followed to produce a legitimate result. The two clearest examples of that are, in some ways, Article 1, Section 7, which most of you will know is how a bill becomes a law, which I abbreviate by HABBAL, etc. in the notes. So if you if you watched American after-school television in the 80s and 90s, you know the cartoon and the song "I'm Just a Bill," And so Article 1, Section 7 says how a proposal goes from being a proposal to actually being signed into law. How is a law legitimately drawn? And there are all kinds of procedural parts of the Constitution. The other two I'll just mention right here, and one we'll come back to later today quite a bit, is Article 5, the amendment portion of the Constitution. How do you legitimately change the Constitution? And you'll discover the Constitution strikes a middle balance between an unwritten Constitution like Britain, where an act of legislation can change the Constitution, an act of Parliament, or the Articles of Confederation on the one hand, which required unanimity of all 13 states. The Constitution, as you'll see, makes amendment difficult but not impossible, and sets up a procedure for legitimate amendments. And you'd have to say that Article 7, which has several major functions, is a procedural one because it delineates the procedure by which the Constitution will become legitimate. The fourth kind of way of designating a part of the Constitution and its function is relational. This is like the first function of declarational, which declares a principle, but by relational, I mean it states the proper relation between different parts of the constitutional system. Article 4, for instance, is essentially an interstate article. It states certain obligations, like if you commit a crime in one state and you flee to another, that's called extradition. The states have to respect the laws and official documents and acts of the other states. So it sets up a relation between the existing semi-sovereign states. In some ways, Article 6, which we'll pay a lot of attention to in this course, which is often called the supremacy article, after it declares, the first part, which declares the laws and treaties of the old articles to be now valid with the Constitution, the most important part of Article 6 is puts the different parts of the constitutional system in relationship. It says, this Constitution and all laws of the United States in pursuance thereof and all treaties of the United States shall be the supreme law of the land. So in some ways, Article 6 says at the top, first of all, at the top, of course, is the American people, from whom the power of the Constitution derives. But after the American people, then the Constitution is the supreme element in our system. Then come the laws and treaties of the national government, and then the laws, constitutions, and actions of the states, which have to conform to the other two elements, the national government treaties and the Constitution. The last kind of function of the 5 functions can be limiting. So a part of the Constitution that limits, it either puts positive duties or negative limits on an institution that reveal what it cannot do. We will see when we turn on Wednesday and examine the internal structure of Articles 1, 2, and 3, the first 3 articles that set up the institutions of national government, that, for instance, after setting it up and designing procedures and everything, in Article 1, Section 8, Congress's powers are listed, what Congress can do. In Article 1, Section 9, it says what Congress can't do. In Article 1, Section 10, it says what the states can't do. In Article 2, Section 4, it's the impeachment proceedings for the president, which you could say put a kind of limit on the actions of the presidency by stipulating how the president could be removed. And in Article 6, the last clause, by the way, you'll see it actually says that no religious test shall ever be required for office under the United States. And people think that the first major protection of religion in the Constitution is the First Amendment, for reasons we'll see on Friday. But no, actually, right there in the Constitution, in Article 1, Section 6, no religious qualifications can be required for office. So with those 5 designations in mind, as we move through, and I try to give an overview of the whole constitutional system today, I'll refer to those terms in terms of what an article is doing, a section, or a clause. So with that in mind, here's how I would describe each of the 7 major articles of the Constitution to give you kind of an overview before we actually start picking it apart on Friday and Wednesday and Friday. So we have the Preamble, which is not just a rhetorical flourish, it's actually an important part of the constitutional system. And it does, and you could say it does 2 things. It's 2 functions, declarational and structural. I've already explained the declarational part. It declares the American people to be the source of the authority of the Constitution. We, the people of the United States, do ordain and establish this Constitution. We are the source of its authority. Now, there is a certain sense in which, and this is connected with one of the PRQs, which is difficult to answer before we discuss it in class. I ask, what parts of the Constitution is the preamble specifically related? And the answer is not just all the parts. It's actually specifically related, for reasons we'll see later, to Article 7 of the Constitution, the ratification clause, ratification article. So how is it a structural thing? What institution is being created by the preamble? You could argue that what the preamble does is it contains the very decisive shift between the Union as a union of sovereign states, as it was under the Articles, to a new union in which the new members of the Union are not the sovereign states, which are no longer sovereign. It declares a new institution, the American people, to come into being. So the preamble not only declares the American people to be the source of authority of the Constitution, it creates the structure of the national American people, from whose national peoplehood the Constitution now derives. And you'll see it's connected with Article 7, because if the preamble states the American people to be the new institution that is the source of the power of the Constitution, Article 7 declares how the American people comes into being as state by state ratifies the Constitution. More about that later. So if you look at Articles 1, 2, and 3, which we'll talk about more specifically on Wednesday, it's clearly these are essentially structural. They set up new institutions. Yes, there was a Congress under the Articles of Confederation, but the new Congress is a completely new institution founded in direct and indirect representation of the American people. the popular representation by proportion in the House is something of an embodiment of the principle in the preamble that the American people are now what are represented in the Constitution. Obviously, Articles 2 and 3 set up the branches of government that didn't exist under the Articles: the presidency, the executive branch, and the judiciary. So again, we'll take apart those three articles, but for the time being, these first three articles are structural in that they set up the new institutions of the national government. Article 4. So see the overall layout of the Constitution. The preamble states the source of authority and brings the American people into being, so to speak, as the Constitution's source of authority. The next three articles set up the institutions of national government. Article 4 turns now to the next most important elements in the constitutional system, which is, and pay very close attention to this, because this will become an issue throughout our history after this, the semi-sovereign states. Again, to go back to the preamble, the Articles of Confederation set up a union of sovereign states in which the American people were not directly represented or actually weren't expressed at all directly institutionally. The Constitution now turns to the American people at the heart of American life, and then it means the states are no longer sovereign states like independent countries. They are now semi-sovereign, half-sovereign. Again, people say, like, how can you be half-sovereign? How can you be half-pregnant? Either you are or you aren't. And you're going to see that messiness is actually part of the constitutional system. So you could say the Article 4 is structural in the sense that it now changes the once sovereign states into semi-sovereign states. And so what you really have is a constitutional system where now the source of authority for both the states and the national government are the American people as a whole. And what the Constitution does is divide the sovereignty of the American people between the Constitution and the national government representing all of them and the states representing some of them. Now, essentially, most of Article 4, now that's kind of a difficult concept to grasp, because you would say, well, didn't the states exist before the Constitution? Yes, they did. But again, as one commentator, Amar Reed Achil Reed Amar says, there was obviously, the country was called the United States of America before, but even though the name remained the same, and even though there was a Congress and states, those entities under the Constitution are not the same. The Constitution creates a totally new form of government, one based upon the American people. There are still states, but they are not what the states were under the Articles. That question, as we're going to see, was a bitter dispute from the beginning, and in some ways took a bloody and horrific 4-5 year war to settle the issue of whether the states still had that kind of sovereignty. It's interesting when you compare the Confederate Constitution of the Confederate States. It's almost identical to the United States Constitution, with two big differences. They abandoned the idea of a 4-year re-eligible president for a single 7-year term of the presidency. So the president of the Confederacy would have been if Jefferson Davis had been allowed to complete his term, would have been a single 7-year president. But then in the preamble, it says, "We, the people of the Confederate States, and the sovereign states assembled." So clearly, the preamble of the Confederate Constitution wanted to get that principle of state sovereignty, which the Constitution in some ways blurs, but I would argue transforms into a principle from sovereignty into semi-sovereignty. Now, what half sovereignty sounds like and looks like in practice, we'll spend some time articulating. Now, the last three articles of the Constitution, after Articles 1, 2, and 3, let me finish with Article 4. It's relational in the sense that, as I mentioned previously, the main business of Article 4 is to state what the relations of the semi-sovereign states are. It says, for instance, criminals fleeing have to be returned. Fugitive slaves, as we'll see. The fugitive slave clause is contained in Article 4. And also the respect, what's called the comity, not comedy like haha, but comity, comity. Comity means the way that nations, international relations respect each other's laws. So the states are obligated, they're put in a relationship with each other to recognize each other as semi-sovereign units. I made up a word to describe what the states are in the constitutional system. They're countryettes or countryoids. They're almost like independent countries, but not quite. The Constitution is over them, and the American people is over both. Article 5. So see the whole system now. You have the preamble stating the source of authority and bringing the American people into being. Then you have in Articles 1, 2, and 3 the structural creation of the instruments of national government. In Article 4, the relational elements of the pre-existing states, now semi-sovereign and with certain responsibilities. So you could say that by Article 4, the essential system has been set up. What's the next logical issue then in the Constitution? Once the system is set up, the next logical issue is how to change it. Now remember, in the Articles, the Articles required the unanimous agreement of all 13 or more states, and that's why it was impossible to amend the Articles. Once you require unanimity in human life, even in marriage, you'll find that that's almost never achievable. So as you're going to see, what Article 5 substitutes for unanimity is procedural difficulty, a supermajority. In fact, here's an important thing to do, because one of the PRQs asks you what kinds of majorities are necessary for what kinds of purposes. Remember, there are several kinds of majorities. There's a simple majority, and majority simply means major, means the Latin for more. And a simple majority is 50% plus one. Then there are several kinds of supermajorities, which the Constitution requires. For instance, to override a veto of the president requires a 2/3 vote of both houses of Congress. To convict of impeachment in a Senate trial, which we just saw this last January, requires a 2/3 vote. To impeach in the House requires a simple majority, but to convict in the Senate of an impeachable offense requires a 2/3 majority. And as we'll see, there are other kinds of supermajorities. And the reason I mention that is Article 5 puts in place two kinds of supermajorities in order to change the Constitution. So to understand how the Constitution contemplates the system being changed by a sovereign act of the people is you have to divide the two supermajorities into 2/3 and 3/4. That is to say, for proposal purposes and for ratification. Proposal means how you actually get a proposal or an idea out there officially. And then remember, it's procedural in the sense that this is the procedure for amending or changing the system. And the other part of the system, once a proposal is out there, is ratification, where it becomes official. The magic numbers for proposals are 2/3. The magic number for ratification is 3/4. And in turn, there are two kinds of proposing amendments and two kinds of ratifying. And we'll see the two ways of ratifying an amendment actually is one way that you group the 27 amendments. Now, what are the two ways of proposing an amendment? The 2/3. 2/3 of both houses can propose an amendment of Congress, which means, and in fact, almost, nay, all of our constitutional amendments have come through the proposal through Congress method. And in this, by the way, the president has no role. The president, you'll see that in Article 1, Section 7, all resolutions that pass both houses of Congress that require the agreement of both houses have to be signed by the president, including laws and other treaties, etc. But when it comes to amendments, it's just the two houses of Congress, 2/3 of both. The other way of proposing amendments has never been activated. It's a kind of a reenactment of the Constitutional Convention. It's when 2/3 of the existing states call for a convention. So the second method, never employed, by the way, is when 2/3 of the states believe that there's a problem in the constitutional system. Obviously, the two methods of proposal of amendments allow amendments to come from either the national government or from the other elements in the constitutional system, the states. So again, the second method of proposing amendments, where 2/3 of the existing states call for a convention to propose amendment, it's like you can allow 2/3 of the states to call for like a second constitutional or third constitutional convention. That hasn't happened yet. Now, when it comes to ratifying, there are two methods of ratification. One, it treats the existing state legislatures as the ratifying device. So when 3/4 of the existing legislatures of the states ratify an amendment, then it becomes official. And there's only been one amendment, and we'll talk about this on Friday, that has been where special ratifying conventions. When we get to Article 7, you'll see that the Constitution was ratified by a special new procedure. This second method of amending the Constitution through ratifying conventions, which has only been done once, and for reasons we'll see on Friday, all the others have gone through the state legislatures. So here's an interesting controversy, which is in front of the country right now. We'll discover one way of organizing amendments is by when they're proposed. And it's interesting that the last amendment, the 27th Amendment, was proposed with the first 10, which were ratified, which is the Bill of Rights. And so that amendment just sat around for a couple of hundred years until an enterprising college student in the 1990s went from state legislatures to legislature and finally got 3/4 of them to sign on. Now, here's the controversy. Starting with the 21st Amendment, the idea of putting a 7-year limit on the ratification process became part of many amendments after that, not all. And then in the 1970s, proposed amendment, the Equal Rights Amendment, was proposed, and actually not part of its text, but part of the congressional resolution said if it wasn't ratified within 7 years. So it wasn't, and therefore the amendment failed by the text of the amendment, by the procedure stipulated. Yet some states, including Virginia just recently, have actually ratified that 1970s amendment. Some people are arguing that the nation should disregard the 7-year limit that is put in. So you should see that in Article 5 itself, there is no time limit, but Congress can put time limits, and typically that's been 7 years, on the idea, I think, that once an amendment is out there floating around, it has to have a germane period or relevant period of discussion. So remember, you could say that in some ways, I say that the Article 5 is somewhat structural in the sense that you could say that what the amendment procedure does is turn the whole system into a giant legislature to consider changing the system. Now, again, the main thing to remember here is it's a means between two extremes. The one extreme would be where you could just change the system by regular legislation of Congress, where a normal political act can change the system, on the one hand, which is, again, to remind you, is the way the British political system works. Britain doesn't have a written constitution. Therefore, when a bill of parliament passes, it can technically change the constitutional system of the United Kingdom. Now, the other extreme, again, is unanimity. So the Constitution intends to make the amendment process difficult, but not impossible. The 6th article of the Constitution is a doozy. It's both declarational, relational, procedural, and limiting. I've already mentioned the sense in which the first clause of Article 6 declares an important principle: continuity between the debts of the United States and laws of the old Confederation and the new Constitution, should it come into being. The primary thrust of Article 6, as I've already said, is relational. In the Supremacy Clause, it puts the Constitution as the most authoritative event or source of authority, the supreme law of the land. And then it says the national laws and national treaties are the second layer in the constitutional pyramid, if you want to call it that. And then the laws, constitution, and actions of the states are at the bottom. So whereas the Articles of Confederation left the core of sovereignty with the states, and in some ways left no power to the whole system or the Congress to enforce it. We talked about this enforcement question in the Constitutional Convention last week. Here, the Constitution is absolutely clear. It puts the different parts of the Constitution in proper relation with the Constitution supreme, national laws and treaties second, and state laws and actions on the bottom. It's procedural in that it also stipulates a procedure for enforcing that supremacy. The judges in each state. So literally, this is what brings judicial review, that the judges at the courts can declare the laws and actions of the Congress and of the president, for that matter, and of the states unconstitutional. What Article 6 has in mind is when a law of the national government conflicts with a law of the state, and both are relevant to settling a case, the judge in that case will declare which of the laws is to be superior. And the Constitution makes it explicit. If there's a conflict between a state law or the national constitution or a national law, the state law has to go. And so it's the procedural element of that is it's the courts who decide that question. The last parts of Article 6 um, are, as I said, limiting the religious test. No religious test for office under the United States. Now, there's another kind of aspect of Article 6 which is present in the oath clause. So one way of empowering judges, in fact, all public officials in the United States, to make the Constitution the supreme, to declare the Constitution, is to require all public officials of the United States, all the way from the president to members of Congress, the Supreme Court, the federal courts, governors, state legislatures, mayors, city councils, county councils, policemen, all public officials in the United States must take an oath to support the Constitution. Now, there is an issue that also bears on religious freedom here, and this is in the PRQs, which you may not have understood. It actually says may take an oath or affirmation, and when we turn to Article 2 in the President's unique oath of office, it does say, I do solemnly swear or affirm. Here's what that language means. The Constitution and the framers probably presumed that most people taking oaths of office would be religious, and therefore would probably swear. An oath is a religious public declaration or statement in which you swear on a sacred text. If the American people lost their minds and elected me president of the United States, the first Orthodox Jewish president of the United States, who probably would give a 5-hour inaugural address and probably lead to a revolution right away. The holy text that I would put my hand on would be the Hebrew Bible or the Torah. If a Muslim were elected president, he'd put his hand on the Quran. If a Christian is elected president, the Christian Bible. So, but what if a person isn't religious? And Article 6 says no religious test shall be necessary. And that's why the language of affirmation is there. An affirmation is when you swear in public. If you testify in court, for instance, and you don't believe in God or you're not a Christian, you can't put your hand on the Bible because the Bible doesn't mean anything to you. So instead, in those circumstances, in court or when you take an oath to support the Constitution, you can affirm. So oath means a religious public declaration. Affirmation means a secular. So that rounds out Article 6 of the Constitution. And so the last major thing that we'll discuss today is Article 7, because in some ways, this is the answer to the PRQ, to a couple of them actually. Which article of the Constitution is the preamble most related to? And here's the answer to that. It's Article 7. So even though I won't be answering all those preparation and review questions on the Constitution that you'll be working on this week, I will answer this one. Because you wouldn't tell from the Constitution or the text of the Constitution how to answer this. So, Article 7 is procedural in that it states the procedure for how the Constitution will become legitimate. And yet, you'd have to say it's structural. Why? Because whereas under the old Articles of Confederation, not only did amendments have to be unanimous, or for the articles to be ratified, it had to be unanimous ratification of all the states for all the 13 existing states at that time to be official. It was ratified by the state legislatures, which were understood to be the seat of sovereignty of the state. So what the Constitution changes, here's the procedural change. Instead of unanimity of the state legislatures, it calls for state ratifying conventions. So and only 9 of the 13 existing states. So it creates a kind of a supermajority for ratification, which is not unanimity. Technically, if one of the original 13 states had not ratified the Constitution, like Virginia or New York or North Carolina, it would be an independent country. And the country would be like around the United States would exist around that state. But in other words, the Constitution contemplates, and this is the critical thing that makes Article 7 part of that Article 7 is the procedural basis by which the American people come into being. Now, for you to grasp this point, you have to understand why the framers chose ratifying conventions as the ratifying mechanism and not the state legislatures. The first point is they didn't want the states to think that one state as a sovereign body was joining another state, that this wasn't a confederation between sovereign states. So they wanted a different method of ratification. Now, in the same way that we discussed briefly in the Constitutional Convention, and we'll come back to this when we discuss the Electoral College later on in the course, you could say, why didn't the framers choose national direct plebiscite or direct vote of the people to ratify the Constitution? If it says, we the people do ordain in the preamble, why not then submit the Constitution to a person-person vote by the entire American people from top to bottom of the continent? And in some ways, the same answer as to why they did not accept direct election, national popular direct election of the president, is relevant here. In some ways, they didn't think this was feasible. Yet, they wanted the American people to be the ratifying element of the Constitution. So instead of the state legislatures, to be sure, which are elected by the people, the ratifying body is a special convention that's called into being just for the purpose of voting the Constitution up or down. Now, to try to explain this, I use a concept that comes from computers, like when you have a virtual disk. It's not the actual physical disk, but it's like a virtual recreation of the disk in the memory of the computer. In a way, the ratifying conventions, and this is the part you have to grasp, the ratifying conventions were understood to be the virtual people. If you couldn't have the people vote directly on the Constitution in person, have the people in each state choose delegates to a convention whose sole purpose was to debate and vote on the Constitution. A state legislature, and this is true today, votes on the whole range of issues that faces government, whether it's police powers, marriage, the definition of marriage, marriage age, all the kinds of criminal laws. But a convention only has one question in front of it. And the framers thought that a ratifying convention in each state wasn't the state itself, it was the people in the state. So, strictly speaking, and this is the most important thing to grasp here, when the ratifying convention in a state ratified the Constitution, it was the people of that state ratifying the Constitution. And so the first state convention to ratify the Constitution was Delaware. And then quickly came Pennsylvania. If you're following what I'm saying, it's not that the sovereign state of Delaware joined with the sovereign state of Pennsylvania and the other sovereign states to create a new confederation. What was happening was, amoeba-like, the people of Delaware, once they ratified the Constitution in their convention, and the people of Pennsylvania, once they ratified the Constitution in their convention, those people merged into a new people called the American people. So what the ratification procedure did was, state by state, brought the American people into being, as the people of one state joined the people of another state through their ratifying conventions. Therefore, it was done state by state because the states were the political units of the time. But it wasn't the states ratifying the Constitution. It was the people of the state. And therefore, you'd have to say that Article 7 is the procedural means by which the American people, spoken of in the preamble, came into being. So, by the time the last state, through its convention, ratified the Constitution, the American people had now been assembled. So, the ratification process of the Constitution is what actually brings the sovereign American people, spoken of in the preamble, into existence. So, that's a difficult point to grasp, and yet it supports the notion that up until that point in human history, the Constitution of the United States was not only the most openly discussed among the people it would be eventually come to govern, it was actually voted into being by the American people. Now, to grasp that point, you have to understand the unique sense in which the ratifying convention in each state, and then it's true that, like in New York, for instance, the vote for the ratifying convention was by popular vote. I mentioned already that Alexander Hamilton was a member of that convention, and so as each convention in each state, I'll repeat it again because it's a difficult concept. It wasn't the state joining another state. As each convention in each state ratified the Constitution, it was the people of that state ratifying the Constitution and therefore joining the people. State by state, the American people came into being, and once completed in the ratification process, became the sovereign entity which is the source of the Constitution's authority to speak for and govern in the name of the people of the United States.